Hello everyone, welcome to the Data Protection Series. My name is Lazarus Carlo. I'm a data protection and technology lawyer in Nigeria, and I regularly provide actionable insights on how you can comply with the Nigerian data protection laws. If this is your first time joining us, please subscribe, like, and turn on your notifications so you don't miss any of our informative and actionable videos. In today's video, we'll be talking about a special category of personal data. Remember, in the first video we did, we talked about personal data, which means any information that identifies any person. Today, we are going to talk about a category of this personal data, and it is called the sensitive personal data. And why is it called sensitive? It is called sensitive because it poses risk and danger to the life and overall well-being of the data subjects. And I will just now list them. But importantly, you should know that while you are collecting people's information, while you are storing people's information, you should be very careful of this category of personal data because it requires extra protection and extra care because of the danger and harm that it poses to the data subjects. And this sensitive personal data includes 1. Genetic or biometric data, such as fingerprints, DNA. So if you are using fingerprints in your offices, for instance, you should be very careful and listen to the end of this video so that you know how you can go about using it. Then the next one is ethnic group. So I know that some organizations or even schools, when people are filling forms, they require them to fill their state of origin or their tribe. That is another practice that you should be very, very cautious of because of the danger that may pose to your data subjects and the additional obligations which the law requires that you must comply with in handling this type of information. So the third type is religion. Of course, in some organizations, schools, non-governmental organizations, even in workplace, individuals are usually required to state whether they are Christians or Muslims. You have to be very careful when you are doing this. So the fourth one is trade union membership. So when people belong to trade union, and you don't need to collect this information unless you comply with the requirements of the Nigerian Data Protection Act, which we'll be talking about shortly. And then the next one is political opinion and views. So when you ask people who they are voting for, or what political party they belong to, or what political party they support, or what political ideology they believe in, you should be very cautious of this because the Nigerian Data Protection Act places a restriction on how you can go about it. So information regarding the next one is health. People's health, their medical history, their current state of health. You should be very careful when you are asking people information regarding this. So these are the sensitive personal data, and they are very sensitive because they can expose the data subject to discrimination. Let me give you an example. So let's assume that an individual is HIV positive. We know that in our society, that person may be easily discriminated against. And when you are asking that person to disclose his or her health status, which may reveal his HIV status, and which will eventually lead to discrimination against that person. So you see how collecting health information may lead to discrimination of a person. Another thing is when you are collecting, for example, people's religious belief or religion, or people's ethnic origin. So this type of information usually exposes people to discrimination or even loss of opportunity. Because of this inherent discrimination against people as a result of this type of information, there is a restriction on how you can collect, store, or handle or otherwise process this type of information. generally there is a prohibition. You are not allowed to collect, store, or use any of this type of information. So which means, for example, you are prohibited from asking people to review their health status to you. You are prohibited from asking people to disclose their religion to you. You are prohibited from asking people to use fingerprints to access a building or to do anything. You are prohibited from asking people to disclose to you their trade union if they are members of any trade union. So generally, you don't have any rights to ask people to disclose this information to you, because disclosing this information may expose them to discrimination. Now, the law has some limited circumstances where you can use this information, where you can collect this type of information from people. And one of the instances where you can collect or use this sensitive personal data is explicit consent. So where the individual involved has given you his or her explicit consent to use his sensitive personal data. So for instance, if someone has come to you for employment and you want to get this person's medical information, you want to know the person's state of health, you can't do that unless the person has given you explicit written consent to get his medical status or health status. So that is it about explicit consent. There are other circumstances allowed by law which permits you to use sensitive personal data. So I have talked about explicit consent. So the next one I will be talking about is vital interest. Vital interest is something you don't want to use because you will rarely need it. You can only use it in a very limited circumstances where the individual concerned is incapable of giving you consent. So if somebody is unconscious or in a situation he or she cannot give you consent, but you need to treat that person. I'll give you an example. Somebody is involved in an accident and is unconscious, but you need to assess his medical history to know how to treat this person, but he's unconscious, he can't give you consent. So in that type of circumstances, you can test him, get his medical information, get his medical history, and then treat him. So that is a very limited circumstance you can use vital interest. So another circumstance where you can use someone's sensitive data is a legal claim. So if you want to use that information to establish a legal claim in court or in any administrative proceedings, or to defend yourself in any such claim or proceedings, then you can use someone's sensitive data. So public health is another one. So if for the purposes of protecting the public from health hazards, the government can use sensitive personal data. A recent example is, for instance, during COVID, governments have to put in measures in place to ensure that the spread of the virus is not widespread. So for example, there was border restrictions, and if people coming into the country have to be tested, and the reason for testing is to protect the general public from this virus. So on that basis, the government can test this person, get their medical information to confirm if they are positive to the virus or not. So there are few other instances you can use people's sensitive data, but generally you are prohibited from using people's sensitive data because it poses them to danger and discrimination. And unless you have some of these exceptions you have mentioned, explicit consent, vital interest, public health, medical emergencies. So unless you have any of these things, you cannot process people's sensitive data. So in your practices, be very careful of this type of information, and when you come across them and you need them, you have to assess your situation and see if any of these exceptions apply to you. So this brings us to the end of this video. I hope you enjoyed it, and if you have not subscribed, kindly do so, as I regularly talk about data protection compliance in Nigeria. Thank you.